Good morning to one and all. This is Dr. M.R.K. Prasad, Dean Faculty of Goa University and Principal of Salgaonkar Law College, Panaji, Goa. Welcome to the class of Access to Justice. We have learned access to justice from earlier MOOCs modules, and we had a lot of discussion on what is access to justice, how do you ensure access to justice. As we learn that access to justice has many facets, and we also learned that the constitutional mandate is that providing access to justice to everyone. It is the obligation of the state to provide equal access to the justice system, and we have learned a great deal under Article 14 that equality is a fundamental right to everybody. So, as a part of access to justice, we have developed 3 modules on how the legal aid was developed over a period of time in securing access to justice, particularly to the poor. The first module would be looking at access to justice developments prior to 1970. The second module would be dealing with the developments between 1970 to 76, and the third module would be looking at post 1976 developments. So, today's class we would be focusing on the first one, how the access to justice has developed prior to 1970 with special reference to the legal aid. So, what is the core objectives of this module or today's class is that we want to learn the pre-constitutional developments leading to access to justice. Then we will look into the contributions of Bombay Legal Aid Society and West Bengal Legal Aid Committee reports. Further, we would be looking at the 14th Law Commission report, which is the first Law Commission talking about the legal aid. And we also look at the efforts of the central government, particularly from 1952 to 1957, how the legal aid became a state obligation. Then we look at the scheme for legal aid to the poor. It was in 1960. Thereafter, we will be looking at the report of the Commission of Scheduled Castes and Scheduled Tribes. Then we will see an effort by a member of the parliament introducing free legal aid bill in 1970 as a private member bill. Then we will also look into contributions of National Conference on legal aid. So, this is what we are going to learn. The objective of this module is to see how these efforts crystallize the legal aid in future. So, before starting, we should understand that society is a web of human interactions. The society is nothing but how do we interact with another human being. And if you look at the initial stage of the development of the society, these interactions are simple. And in that sense, the primary function of the law is to regulate these human interactions that takes place in the society. The human interactions, when they are simple, dealing with that, the law is also simple. Therefore, there are no much trouble in understanding the law or following the law when the law is so simple. But however, human interactions becomes complex. They become complex when the societies change over a period of time. When human interactions becomes complex, social relations becomes more complex, law automatically becomes complex to deal with interactions. So, once the law becomes complicated, it becomes difficult for many people to understand it, and that results for a need of providing legal aid, and particularly the poor people who would not be able to afford legal services to understand these complex intricacies. So, therefore, the legal aid has become over a period of time an integral part of promoting access to justice. And if you look at the Indian history, it is no stranger to this development. So, recognizing its importance, the government India realizes that it is its obligation to provide equal access to justice in a new independent India. And that is the reason why even the constitution, when it was adopted, access to justice is its prime objective. And the many judges, jurists and even the research scholars contributed towards this concept, and they contributed to the growth of the free legal aid what we are looking at today by several reports, several committees, etc. So, if you see that the roots of the free legal aid in India could be largely attributed to the Bombay Committee report. The Bombay Committee report drew the attention of the government to another report that was submitted in England, Rushcliffe report, which was submitted in 1944. With this backdrop, this module would be looking at how the origin of the legal aid has taken place, how it was grown and developed over a period of time till 1970 in India. So, this slide, it shows the various developments that taken place prior to 1970, which over a period of time in this class we will deal one after one. Now, to start with the Bombay Legal Aid Society, as I already said that the Bombay Legal Aid Committee was the main reason for starting it. The Bombay Legal Aid Society was registered in 1924 to provide free legal aid to all those who cannot afford. But for providing free legal aid to the poor, the society enrolled a few advocates to the panel, and it used to get financial assistance from the donations, government grants, membership, subscriptions, etc. As I told already, Bombay Legal Aid Committee has largely relied upon Rushcliffe Committee's recommendation. If you see the Rushcliffe Committee recommendations on legal aid was submitted to the British Parliament, and the British Parliament accepted its recommendations, and as a result it enacted a Legal Aid and Advice Act way back in 1949. So, therefore, the Bombay Legal Aid Society brought this report to the attention of the central government and requested the government to appoint a similar committee to make recommendations on the need for legal aid to the poor in India. So, the government of India in 1946 itself wrote to the provincial governments, which you could loosely define them as state governments now, to provide free legal aid to the poor people in both civil and criminal cases. But the provincial governments expressed their inability on the ground that it would be very difficult for them as there is no adequate finances, and as such that the existing provisions in civil cases is sufficient to provide legal aid, but in criminal cases it will not be able to provide as there is no financial capacity to the provincial governments to provide free legal aid. However, the government of Bombay appointed a committee in March 1949 under the chairmanship of Justice Bhagwati, and this committee has submitted its report in October 49. The committee has made three major recommendations. The first one, the legal aid was the government's responsibility and the state was under duty to provide a lawyer if a person, a citizen, unable to hire a lawyer due to any financial constraints. So, therefore, a poor is entitled for a free legal aid and it becomes the obligation of the state. And number two, all the lawyers should be under the duty to undertake legal aid work. That means, being a professional, at least certain amount of time you should spend for providing free legal assistance to the poor. And further, the third recommendation made by the committee is that every lawyer at least should provide free legal aid for 6 cases without any fees. And if they accept more or if they are assigned more cases, then the fee will be prescribed by the government, which is equivalent to the government pleader. That means, the first 6 cases you should be freely providing, and if the more cases were assigned to them, then he should be paid equivalent to the government freedom. And at the same time, the West Bengal government also appointed a committee under the chairmanship of Sir Arthur Trevor Harris, who is the Chief Justice of the Calcutta High Court, to make suggestions for judicial reforms in the state. So, the committee, in addition to suggesting the judicial reforms, also dwelt on providing legal aid. However, the same reason, that is the financial inadequacy, the state government unable to implement the recommendations of this committee.